So I've just seen this nuisance lawsuit that a plaintiff has filed against a barbecue restaurant in East Nashville. And she's claiming that the smoke smell from the smoked meats is permeating her house and affecting her health. And she's filed a lawsuit for nuisance, and she's trying to shut this barbecue place down. And people are asking online, can she win? Could this actually happen? And the answer is maybe, but it's going to depend on a lot of things. So first of all, she says that this business is not properly zoned to be operating the way that it is. I don't know whether that's true or not, but it may or may not matter, because even if you are a lawful business, you can still be committing a nuisance. So I just read a case, kind of researching for this video, out of San Antonio, Texas, where a hotel was wood grilling on the Riverwalk they have down there. And the smell from the wood grill was affecting the dining area of another hotel. So 2 hotels were involved in this litigation. And the court said, yeah, you've got to stop your wood grilling because it's affecting the customers of this other hotel. Now, they didn't totally shut down the other hotel that was grilling, but it just shows you that you can be lawfully doing something but still committing a nuisance. So whether it's zoned properly or not is going to be a relevant factor, but it's not going to be a dispositive factor, I don't think. So the next thing is, how bad is this smell? Do most people agree that it's a bad smell? I mean, it's kind of interesting. You can have a nuisance, which is the interference with the use and enjoyment of your property. You can have that be sound, like if they're playing music too loud, or runoff if their drainage isn't right and they're sending water onto your property or something. And you can also have it be smell. And a lot of the cases involve, for example, sewage smells, right? Something that's really foul, gasoline pollution. Smoke from a barbecue joint possibly qualifies, but it may depend on what the neighbors say. So it may depend also on the proof. For example, has the plaintiff had air quality tests done outside and inside her home as compared to elsewhere in the neighborhood to show that, yeah, actually this is really an unhealthy level. She alleges in the complaint that she has intensified her asthma regimen. What does that mean? Does she actually have a letter from a doctor saying, yeah, you're deteriorating because of the smell? Or is it just going to be testimony like, yeah, I had to use my inhaler a couple more times, right? How strong is that proof? That's going to matter. One other thing that I think is going to matter is that she's only lived here for 2 years, and this restaurant was in operation well before that, right? She knew the restaurant was operating when she bought the house. Now, that's not going to be a defense to nuisance, that the plaintiff so-called came to the nuisance or coming to the nuisance. But it is a factor in this whole thing, that this business has been around for a while. And if there's proof that the neighborhood likes the business and it's got some social utility, then that's a factor the court can consider. So it's going to depend a lot on proof in terms of whether the plaintiff can win here. Now, what are the potential outcomes? It is possible that a court could order this restaurant to shut down. I don't think that's the most likely thing. More likely would be if the plaintiff establishes the nuisance and elements, then there could be some sort of crafted resolution, like increased smoke mitigation, fans, that sort of thing, and make the business spend a little bit more money on that. That's if the business loses. Otherwise, it could just be plaintiff fails to establish the elements of nuisance, fails to establish that this is really a serious invasion of her use of her property, and she loses. So we'll see what happens. If you liked this video, please leave me a Google review. I'll put a link in the description. That would really help. Thanks for watching.